Well, hello and welcome back to my channel. You're with the Learner Lawyer. Hello. And if you're looking and saying, Joanne, you look like you're in your pajamas, you are correct. I've been out. I've got home. I don't know about you. I like to, when I get home and I'm not going out again, put my pajamas on because I'm nice and comfortable. Plus, the weather's horrible outside, so I'm nice and warm. So I hope you're all doing well. Hello, Plan to Create. So there have been some massive Instagram postings going on today with from Without a Crystal Ball, all about the Josh Duggar. Let me just say, she was wrong. He was never going to get the 20 years. I thought he'd get closer, more like the minimum, but he's, been, and he could get out. It's likely that he'll do 10 years and then be released with the really heavy parole conditions that he will have to endure. So let's have a look at this. Now, I actually have some issues. I've only seen snippets of the defense and the counterclaim, but I have lots and lots of issues with what I've seen. So I'm assuming I'm going to have lots of issues. And if you're wondering what I'm doing, I'm looking for some paper because I'm going to have to take notes. See, this is how organized I am. I just came straight home, jumped straight live, didn't get myself organized. Has anybody read it? And what do you think? What's everybody's thoughts on it? Now, I'm interested to see that she's added extra parties to this, in the counterclaim. And I'm interested to see people talking that Julie Chrisley's got involved. I don't know what on earth that would be doing. It's 18 pages. And here is the issue. I've got a couple of issues that I have. So we're going to just have a look. I'm just having a look. Well, there seems to be some. Oh, that's what people are saying. Plan to Create. People are saying there are some porcupines in there. I read that somebody has said that she's implicated Julie Chrisley into the counterclaim. And what's Julie Chrisley done? Anyway, so let's have a look at this. Let's discuss it. I'll also preface to say that I am studying Australian law. I know nothing about how the US law system works. And what I find to be really interesting is that one of the things is that she's trying to get from what I've read, we'll find out, she's trying to get Without a Crystal Ball removed from the suit. Yet, interestingly enough, she's done all her postings under that Without a Crystal Ball. I don't know how she's going to separate personal and business. And under vicarious liability, particularly in Australian law, Oh, hang on. Is that better? I took myself out the stream. Hello. I took myself out the stream. Oh, is that better? Oh, I'm dense sometimes. My head is not screwed on at times. Is that better? Yes, I've got to remember to not take me out of the stream. I took myself out the stream. I was sitting in the back. Anyway, okay. So we've got Todd Chrisley versus Catherine. So answer and counterclaim. Then she is countersuing Seven Seas Production, Courtside Group, and Live One Group. Now, so for that, they become the defendants. She becomes a plaintiff. Now, this says, except as hereinafter specifically admitted, defendants Catherine Mansky Polson, and Without a Crystal Ball, LLC, WOACB. Don't know why they write it like that. Collectively, defendants specifically deny each and every allegation of plaintiff Michael Todd Chrisley or plaintiff's complaint and put plaintiff to his strictest proof. Hello. Just go look at all her Instagram and YouTube videos, eh? Anyway, defendants for their answer and affirmative defences to plaintiff's complaint are as follows. Regarding the allegations contained under nature of action encompassing paragraphs 1 through 7, defendants generally deny each and every allegation therein, but aver to these paragraphs specifically as follows. I like this word generally. They generally deny. They don't categorically deny. They don't partially deny. They just generally deny. So defendants deny. I mean, this is a standard thing. You deny paragraph 1 and put plaintiff to strictest proof. So they're saying you need to prove that I defamed you. They deny paragraph 2, deny paragraph 3, 4, and 5, and 6, and 7. Now, I tried to find the original complaint and I couldn't find it. So I will do that. So regarding the allegations contained under parties encompassing paragraphs 8 through 11, defendants generally deny each and every allegation therein, but aver to those paragraphs specifically as follows. Which is interesting because here we go, because they're saying that they deny those paragraphs. However, they admit to paragraph 8, 9, 10. Defendants deny that Polson and WOACB are alter egos and one in the same as alleged in paragraph 11 of the plaintiff's complaint, and aver that Polson is the owner of WOACB, a single member LLC organised in the state of Minnesota. Defendants specifically deny any wrongdoing. So she admits that she's the owner, that WOACB is not the alter ego, or that, which I find to be an interesting because, yeah. And one in the same as alleged. Well, they are one in the same, aren't they? She does all of her statements under WOACB. Now, she doesn't have her Katie Joy Live. She's got Without a Crystal Ball on Instagram. So how can she not say that they're not one and the same? Regarding the allegations contained in under background encompassing paragraphs 12 through 36, they denied. I mean, this is just a standard denial. They admit paragraph 12, admit paragraph 13. Defendants are without sufficient knowledge or information to form a belief as to the truth of the allegations in paragraph 14. They admit paragraph 15, admit paragraph 16. Defendants are with sufficient knowledge or information. What? Wait on. They've made a mistake. Paragraph 17 is supposed to say defendants are without sufficient knowledge. Here they're saying defendants are with sufficient knowledge or information to form a belief as to the truth of the allegations in paragraph 17 of the plaintiff's complaint and therefore deny the same. That whole paragraph is contradictory. Who did your proofreading? Katie Joy? Who did your proofreading? Read that read that out loud and tell me that that makes no sense, please. Somebody tell me. Make this make sense. Make this make sense. Okay, so I think it's supposed to be the same as paragraph 14, that defendants are without sufficient knowledge or information to form a belief as to the truth. But paragraph 17 says, Todd Chrisley's lawyer, please pay attention to paragraph 17 because it changes the whole meaning, that they are with sufficient knowledge or information to form a belief as to the truth of the allegations in paragraph 17, but they'd still deny it. Defendants admit paragraph 18 to the extent that defendant Paulson uses the stage name. The stage name, Katie Joy Paulson. Sorry, I shouldn't laugh. Stage name? I thought that was her name. Defendants admit paragraph 18 to the extent that the defendant Paulson uses the stage name and the name for stay on name should be a lowercase n. This is very poorly typed. Katie Joy Paulson, but specifically aver to the statements referred to in plaintiff's complaint were made after reviewing the public statements of Lindsay Chrisley. The allegations of paragraph 18, and specifically any and all allegations of falsity, are otherwise denied. Defendants admit paragraph 19 of the plaintiff's complaint. They deny paragraph 20 of the complaint and 21 of the complaint. Oh, this is hilarious. Defendants admit that she discussed some claims or statements made publicly by Lindsay Chrisley, referenced in paragraph 22 of the plaintiff's complaint made, but specifically aver that such statements were made after reviewing the public statements of Lindsay Chrisley. The allegations of paragraph 22 and specifically any and all allegations of falsity are otherwise denied. I didn't realise this was going to be a comedy. Defendants admit that the claims or statements referenced in paragraph 23 of the plaintiff's complaint and each and every of its several subparagraphs were made, but specifically aver that such statements were made after reviewing the public statements of the subjects thereof. The plaintiff's interpretations of the statements in paragraph 23 and each and every of its several subparagraphs are plaintiff's own, for which defendants are not responsible. And those interpretations and characterizations, specifically any and all allegations of falsity, are otherwise denied, and will continue to so deny them in every allegation in which the plaintiff mentions the sex tape statements. Oh dear. Defendants admit that they made some statements through social media channels, but denied paragraph 24 of the complaint, paragraph 24 of the plaintiff's complaint, to the extent that includes any of the plaintiff's own interpretations and characterizations of what he refers to as sex tape statements. Defendants deny paragraph 25 of plaintiff's complaint and puts the plaintiff to his stricter proof thereof. Defendants deny paragraph 26 of plaintiff's complaint and put plaintiff to his strictest proof thereof. Defendants are without sufficient knowledge or information to form a belief as to the truth of all of the allegations in paragraph 27 of plaintiff's complaint and therefore deny the same and put plaintiff to his strictest proof. It's just a copy and paste job. Defendants admit paragraph 28 of plaintiff's complaint to the extent that certain statements have been removed from the defendant's social media pages, as is defendant's right to do so. Defendants specifically deny all the other allegations in paragraph 28 of the plaintiff's complaint and put plaintiff to his strictest proof thereof. Defendants deny paragraph 29 of plaintiff's complaint and put the plaintiff to restrict the proof thereof. Defendant admit paragraph 30 of plaintiff's complaint only to the extent that she made statements through her company on various online platforms. However, defendants specifically deny any assertion that the statements were false or defamatory, or that defendants made any calculation regarding anything other than whether items were newsworthy. Defendants deny paragraph 31. They denied 32. Paragraph 33 as the allegation of that the reference claims bombastically referred to plaintiff as the false and extortion claims are false and put plaintiff to strict as proof. Plaintiffs admit paragraph 33A of plaintiff's complaint to the extent that the statements were made. Defendants specifically deny that the false and extortion claims make any untrue statement about plaintiff and aver that such statements are true and based on publicly available information reviewed and confirmed by defendants prior to her reporting on their subject matter. She's going to have to prove that. Plaintiffs admit paragraph 33B of plaintiff's complaint to the extent that the statements were true, that the statements were made. Defendants specifically deny that the false and extortion claims made any untrue statement about the plaintiff and aver that such statements are true and based on publicly available information reviewed and confirmed by defendants prior to her. What on earth is she saying? So she denies that she made the statement, but she states that if that any statement made was based on the fact that it was already publicly available and confirmed by Chrisley before she reported on it. Right, okay. Defendants admit paragraph on her social media, but otherwise denies any other allegations or implications, denies 35 and denies 36. Now we're going to look at defamation per se. Sex tape statements. Regarding the allegations contained on the count 1 defamation per se, encompassing paragraphs 37 to 43, generally deny each and every allegation therein, but aver to those paragraphs specifically. Terry says, I think she's using the word deny too much. In a nutshell, she's in denial. Look, the thing is, it's you generally deny, you would deny everything. Or you'd plead partial truth, or you'd plead that it was in the public interest, or you would plead that it was, yeah. I mean, as I said, that paragraph before where she said that instead of putting without, with knowledge, that paragraph 17, I reckon, could be, you could have a little bit of fun with that paragraph in court. So paragraph 37, the plaintiff's complaint does not contain any factual allegations and requires no response. To the extent the response is required, defendant denies. So they're saying there's no factual allegations in that claim, therefore we're not responding. However, if we have to respond, we deny. Defendant admits paragraph 38 of plaintiff's complaint to the extent she made statements over social media, but denies plaintiff's interpretations of those statements. Now, this is very interesting. In Australia, it comes down to the reasonable test. So would a reasonable person, upon reading those statements, how would they interpret it? Now, they deny the interpretation made by the plaintiff, right? However, the argument would be, if a reasonable person had read those allegations, would they interpret the claims the same as the plaintiff, or would they interpret them the same as Katie Joy? As I said, I was trying to find the original complaint and I haven't found it. I know I've got it somewhere, but I'd like to see what paragraph 38 is, and I'd like to see we put that to the reasonableness test. Now, in Australia, just recently, there was an appeal in court over the meaning of the word "are apologist." The appeal has been approved. I've not seen it, Terry. I've seen lots where it says they deny. I've not seen it like this either. I just thought it was because I was from Australia. But yeah, I've not seen it. I've not seen it like this. So she denies paragraph 39, 40. They admit paragraph 41 to the extent that they made certain statements. However, defendants deny each and every remaining allegation. Paragraph 41 and specifically deny any assertion that the statements were false or defamatory. The thing is, it's not up to them to, I mean, she can say that it wasn't defamatory, but again, paragraph 42 calls for a legal conclusion and requires no response to the extent that a response is denied. Paragraph 42. And they deny paragraph and put to the strictest proof. I thought she had to prove that what she said isn't defamatory. I didn't realize the burden of proof was on Chrisley. I mean, our defamation law is all messed up in Australia, but with the Google and Barilaro one, it was up to Google to prove that what they said wasn't defamatory. Well, they admitted defamation, but it didn't matter. A lot of it was how Barilaro felt and the effect it had on him. He didn't actually have to prove it. They had to prove it. So I'm just interested to see that. I'll be interested to see what the US lawyers have got to say about it. Count 2, defamation. So regarding allegations contained under count 2, defamation, 44 defendants deny each and every allegation. Paragraph 44 does not contain any factual allegations, requires no response. They would deny. It's another cut and paste job, probably. Meet paragraph 45 to the extent she made statements over social media but denies plaintiff's interpretations of those statements. To me, as I said, this comes down to reasonableness. How would a reasonable person interpret that statement? What for me, and then it would say, however, it was in the matter of public interest or something. You would then talk about your defence, but you can't say the plaintiff's feelings have been hurt and that's not my fault. That's essentially what she's saying. She's saying, she's saying Chrisley's fees are hurt. He's read it wrong, and therefore it's all his fault. That, he needs to toughen up. So it's very interesting. Defendants deny paragraph 46, strictest proof. 48 is the same. It's just, as I said, it is just exactly the same. Deny, and specifically any statements were false or defamatory. Again, my understanding is if she's got to prove that, if she's denying that the statements are false, then she's stating that the statements are true. Well, then it needs to be proven. That's my, Regarding the allegations contained under count 3, defamation per se, extortion claims. Is that how you spell extortion? I don't know. Encompassing paragraphs 50 to 56, defendants generally deny each and every allegation. And again, we've got another copy and paste job. Paragraph 50 does not contain any factual allegations, no response. However, if there is a response required, it's denied. Admit to paragraph 51. And again, denies the plaintiff's interpretations of those statements. Again, she's saying it's Chrisley's fault that he's interpreted them as defamatory because that's not my interpretation. Again, under my understanding, and again, I'm talking about mainly Australian law, I don't know, it is the reasonable test. Would a reasonable person, upon reading what was written, come to the same conclusion? So denied calls for legal conclusion. Huh? Defendants admit paragraph 54 of plaintiff to the extent that Paulson made certain statements to further her pecuniary interest. She's saying that she's admitting that she's profiting off this. However, defendants deny each and every remaining allegation and specifically deny any assertion that the statements were false or defamatory. Has somebody read this? So remember, pecuniary interest is a matter where one may have a direct, indirect conflict in relation to a matter under consideration. Or a pecuniary interest refers to money. So she has admitted that she's made the statements for her own financial gain. However, denies that what she said was defamatory. Where is the face palm? Where is the face palm? And she's just posted something else about Todd Chrisley now. So she's playing with fire, in my opinion. So let me just repeat that again. Defendants admit paragraph 54 of plaintiff's complaint to the extent that Paulson made certain statements to further her own pecuniary interest, her own financial interest. However, denies each and every remaining allegation. Wow. She's admitted that she's made the statements for her own financial gain. Yeah, there's a few bombshells in here. Regarding allegations under under defamation, comments in paragraphs 57 to 63, they deny every allegation. Paragraph 57, a plaintiff's complaint does not contain any factual allegations and requires no. Oh, again, we're just doing the same thing. Admits paragraph 58 to the extent she made the statements. Legal conclusion 60, legal conclusion, they admit paragraph 61 to the extent that Paulson made certain statements to further her own pecuniary interests. However, defendants deny each and every. Yep. So again, she made statements for money. She's admitted that. She's admitted that. She admits it. She's admitted stating those statements for her own, for money. However, denies that what she said was false or defamatory. Any allegation, paragraph 64, to the extent the re-allegation and incorporation relates to factual allegation. Plaintiff's request for relief does not contain factual allegations and therefore no answer is required. To the extent an answer is required, defendants deny the same. So they're saying, we don't believe that any of the allegations are true because, and remember, Minnesota, you don't actually have to prove it in the pleading stage. It's discovery that it all comes out. However, that she's saying, however, if we do have to give an answer, we deny it. Plaintiff's complaint fails to state claim upon which relief can be granted. Each of the plaintiff's 4 counts as pleading paragraphs 37 to 63 of plaintiff's complaint claims solely against defendant Katie Joy Mansky-Paulson. Plaintiff's claims in 37 to 63 of plaintiff's complaint do not state a cause of action against Without a Crystal Ball, and Without a Crystal Ball should be dismissed as a party. Sweetheart, you cannot be dismissed. You cannot make statements under a business name and then not do it. And besides, I thought you had business insurance. Your business insurance won't cover it. Defendant hereby incorporates, as he fully set forth herein, all the affirmative defences in plaintiff statements are true and therefore not defamatory. Okay, Prove it. Prove it. Plaintiff statements are true. And then, however, alternatively, plaintiff statements are statements of opinion and therefore not defamatory. I've got a foot in both camp, Paulson. I'm stating that the statements are true and not defamatory. However, if you think they are defamatory, they're my opinion. Right. There's no background, there's no defense in law. Defendants reserve the right to assert such additional affirmative defenses as may be appropriate and as learned through the course of discovery up through the conclusion of trial of this matter. Discovery is where it all comes out. Now, it's interesting. Catherine Mansky-Polson, is counterclaiming against Todd Chrisley and 7C's Production, Courtside Group, and Live One. This is where we're going to get interesting because we could actually have a jurisdiction issue. Remember, this is in Minnesota. You tell me what you think. Counter plaintiff Catherine Mansky-Polson is an individual resident of the state of Minnesota with her place of residence located in Hanover. Upon information belief, counter defendant Michael Todd Chrisley is an individual resident of the state of Tennessee with his place in residence located in Nashville and a national celebrity by way of national reality television programs and a podcast resulting from the same. 7C's Production, Inc. is a Georgia corporation and production company owned by Chrisley. Courtside Group is a Delaware corporation involved in providing podcast hosting services, including Chrisley's podcast, Chrisley Confessions. Live One, Inc. is the owner of Podcast One, a Beverly Hills, California-based national advertiser supported on digital down audio network producing podcast content, including Chrisley's podcast, Chrisley's Confessions. Now, here we go. Jurisdiction. The court has jurisdiction over plaintiff over Minnesota statute by virtue of the fact that Chrisley's contacts with and statement about Polson have caused injury to her in Minnesota and described further herein. Additionally, Polson has compulsively counterclaims per Rule 1301 of Minnesota Rules of Civil Procedure on the basis for Polson's counterclaims. Wait. Hang on. This makes no sense. Additionally, Polson has compulsory counterclaims per Rule 13.01 of Minnesota Rules of Civil Procedure because the basis for Polson's counterclaims arises out of the same set of events Chrisley uses as the basis for his claims against Polson. Whoa. Does anyone make sense of that statement? Can anyone make sense of that paragraph? Can someone give me that paragraph? So right. So it looks like they're trying to say, I think, and it's stated very badly, that injury was caused to her in Minnesota where she lives. And because Todd Chrisley's filed his claim in Minnesota, she's replying and therefore the counterclaim would be proper. I don't know. Venue is proper under Minnesota Statute 541 as Wright County is the county in which the action began and the venue is properly located therein. Oh, no. No. Polson is a successful online personality and entertainment journalist who runs a YouTube channel called Without a Crystal Ball and goes by the stage name Katie Joy Polson, which covers a variety of topics including reality television, celebrity gossip, trending news, crime, personal video, web blogs, i.e. vlogs, and more. Actually, didn't she just say on her Instagram the other day that she only covers cults? The channel is known for covering reality television personalities such as Chrisley. Without a Crystal Ball currently has approximately 233,000 subscribers and accrued more than 115 million individual views since it was established in October of 2018. Chrisley is a national reality television personality, podcast broadcaster, real estate. Oh, Terry says, darn, I was going to ask Terry's just, I was going to make you make sense of this. It doesn't make sense, except she's full of herself. So podcast broadcaster, real estate mogul, and celebrity who regularly thrusts himself in the public eye. For the last 9 years, Chrisley has been a central figure of the US reality television show Chrisley Knows Best, which features his wife and children and has spawned multiple spin-off series. He's also the progenitor of the 186 episode podcast Chrisley Confessions, which he co-hosts with his wife Julie Chrisley. Chrisley's Confessions is a 7 Seas production hosted by Courtside Group and distributed to multiple streaming by Podcast One. The Chrisley reality television show focuses on the Chrisley family, including their often tumultuous family dynamics. The Chrisley family have voluntarily and without any coercion televised and discussed their many family disagreements and legal issues on their show and podcast for monetary gain. Well, that's right. So that's why she's doing it for monetary gain, because they've done it, and have given television interviews through other news outlets on the same. You're not a news outlet, darling. Miss Paulson has reported on many of these televised and family reported issues. Even in light of all the other reporting of his family's internal and external troubles by the Chrisley family themselves and other news outlets, Chrisley apparently took particular issue with Miss Paulson's reporting. Well, we've all seen the video footage of where she says that he's gay. I mean, we've all seen it. It's all around. So, yes, no, I'd take exception to that too. In response to Miss Paulson's reporting on the Chrisley family, Chrisley and his wife Julie have continuously made personal attacks against Miss Paulson through their various media outlets to a large number of followers, including sophomoric attacks on her personal appearance and reckless allegations about her fitness as a mother. Oh, we're going down this chestnut. On episode 148 of his podcast, Chrisley stated that Miss Paulson is intent on destroying families, destroying people, but that is because she doesn't have God and she doesn't know God. The Chrisley's reckless statements and vitriol regarding and directed Miss Paulson and her family have resulted in listeners anonymously swatting Miss Paulson's home and calling the police and social services to make false reports. Hang on a minute. I thought that was under the Tardy. I thought that was Tardy's fault. Here we go again. We're gonna blame the trolls on somebody else. In addition to his attacks on Miss Paulson personally, the Chrisleys have chosen to further attack Miss Paulson's husband and minor child, making demonstrably defamatory statements about them as well. The Chrisleys have broadcast their desire for others to file lawsuits against Miss Paulson and set up an email account to which they requested people to send information about Miss Paulson for encouraging the same. I don't believe that that's an issue. Remember, didn't she set up a tip hotline at one point in time if you've got a tip? Further, upon information and police, hello Bella, upon information police, Mr. Chrisley privately messaged other individuals and requested that they join in his harassment of Miss Paulson and her family. Oh, here we go. We got the harassment claims again. Terry C says the sick child and I'm a victim chart card is coming. Paulson re-alleges and incorporated paragraphs 1 to 19 as in fully set forth herein. Chrisley made numerous false and injurious statements about Paulson and her family using his podcast and social media platforms to publish and circulate these statements. Chrisley's false and libelous statements were published to one or more third parties and to the public in general. Chrisley knew or should have known that these statements about Paulson and her family were false. Chrisley made false statements asserting that Paulson had committed criminal acts and or was engaged in criminal activity, and or that would be understood as describing criminal behaviour. Chrisley's false statements about Paulson and her family were intended to, or reasonably likely to, damage Paulson and her personal business and personal and business reputations, as well as her standing in her local community. I didn't believe she had a standing in her local community. She doesn't leave the house, allegedly. Chrisley's statements constitute defamation per se, and as such, general damages are presumed. I can't wait. I can't wait to see Todd Chrisley defend this one. Third-party defendants 7C's production, Courtside Group, and podcasts are all voluntarily participating in disseminating or broadcasting Chrisley's defamation. Sweetheart, Without a Crystal Ball has voluntarily participated in disseminating and broadcasting Paulson's defamation. You can't say Without a Crystal Ball cannot be sued by Chrisley and then go around and sue his parties for stuff that he said. You can't have it. It cuts both ways. As a direct and proximate cause of Chrisley and the third-party defendants' action, Paulson has suffered general and specific damages, including to her reputation, business and standing in her community, in an amount to be established at trial, but which exceeds $50,000, together with interest costs. Attorney's fees may be available, or, this is going to be good. Harassment. So he used his podcast and social media platform to make repeated statements intended to frighten, threaten, or intimidate Paulson and her family. He's repeatedly made statements about Paulson, encompassing false statements about her as a person, mother, wife, and professional, as well as statements attacking her husband and child. Didn't she do the same to him? Chrisley took action encouraging others to commence legal action against Paulson using his podcast and social media platform. These statements constitute harassment under Minnesota Statute 609. As a proximate result of Chrisley's harassing behaviour and statements, Paulson and her family have suffered general damages in an amount to be proven at trial. Oh, no, now we've got emotional distress. The conduct of Chrisley, as herein described, was extreme, outrageous, and beyond the bounds of decency tolerated in a civil society. Paulson and her family have been the targets of swatting and other false reports to police and social services since Chrisley began posting his false and reckless statements. Hang on a minute, I thought that happened. I thought she'd had 4 calls before. You can't keep changing the story. If Todd Chrisley's watching this, go back to her social media posts around the Tardy lawsuit, her last lawsuit. She's made the same allegations to his large national audience, and he encouraged his listeners and readers to harass and threaten Paulson's husband and minor child. Paulson, her husband, and her minor child have been threatened by others at the direction of Chrisley. Don't forget, there was around the time the laundry case, apparently, somebody rang in to say that was Brian Laundrie was living there. Is that Todd Chrisley's fault now? Encouraging adults to harass and threaten children is objectively outrageous conduct intended to inflict emotional distress on Paulson. I don't believe anybody threatened to. I've never heard anything bad said about her child. I've never heard anybody say anything, including the Chrisleys, about her child. How can she say that her minor child has been threatened? I've never heard it. I've never heard anybody say anything bad about that boy. The only person that I've heard talk badly about her son is her. Katie Joy is the one that has said stuff bad about her son. Like she said that he's like he'll never really have a life. He'll have to live in the basement, and she's going to need to get a conservatorship over him. She's the one that's done it, not anybody else. Chrisley's conduct was intended to cause Paulson and her family severe emotional distress or was perpetuated with reckless disregard as to the probability that plaintiffs suffer severe emotional distress as a result. All of this goes back to her behaviour. As a proximate result of Chrisley's false, defamatory, and harassing statements, Paulson and her family have suffered general damages, including emotional distress and mental suffering, in the amount to prove it. Remember, she's holding Chrisley to strict proof. She's going to have to prove it. So, defendants Katie Joy Paulson and Without a Crystal Ball pray that judgment be awarded in their favour. But hang on a minute. Damages in excess of $50,000. Consequential damages related to Chrisley. harassing statements and actions towards Miss Paulson personally and to her family, consequential damages relating to the intentional infliction of emotional distress. Chrisley's reckless statements and actions have caused Miss Paulson personally and to her family. Temporary and permanent injunctive relief, prohibiting Chrisley from any future posting about Paulson, her husband, or her child, or from inciting or soliciting such posting from others. That is what if I was Chrisley, I'd be doing the same. That Paulson be awarded judgment for her attorney's fees, will cost disbursements, expenses, and reasonable attorney's fees incurred in the connection. Relief for that this court seems. Yeah, like it hasn't set the world on fire. I'm just surprised that we've got the swatting back again. I'm just really surprised we've got the swatting claims back, and now this time it's Todd Chrisley's that Todd Chrisley is at fault. I just don't know what to say. It's not that exciting, and I'm certain that Chrisley can support everything that he said. What do you reckon? It's a bit underwhelming. Also very predictable. So, very predictable. So, yeah. So, what do you reckon? Tell me what you think about that. What do you think? Well, interesting. The thing is, Terry, the thing that I'm finding really interesting is that all contradicts what she said on her Instagram the other day. If we go to her, let me find her Instagram, because she talked about why she doesn't cover the herd dep, and she said she only covers cults. But in that posting that in that document, that legal document, we're told, I mean, that's straight off her website, that she does celebrity gossip. What is it? Let me go back down here. Oh, gee, it was such a long time ago. Or did she? I'm just trying to find it. I know I read it the other day. So Duggar, oh, that's right, because she's been on Duggar. She's been on the Duggar bandwagon for who knows how long. I'm sure she said that she followed cults. She only did cults. And I can't find it now. Of course I can't. So, yeah, I don't know, which contradicts everything that she's said. Did you see that on her Instagram? Oh, here we go. Here we go. Here it is. Okay. I'm an independent. My reporting has been related to the cult surrounding the Duggars for years. That doesn't change with tomorrow's verdict. For the most part, I don't cover celebrity civil trials. I haven't covered the case for a reason. The social media bullying surrounding the case is too much. I feel that if I were neutral in my reporting, I would end up destroyed by Johnny's fans. I have been and continue to be neutral in the case, and I have no vested interest in the outcome. Depp Heard are not in a cult. which is outside the scope of my general interest. They are also not reality TV stars. So, she only covers cults. And here, as it stands, both sides believe possession will be. This means the max he can be sentenced is 20 years. Given Josh's behaviour throughout, I expect the judge to sentence him to the maximum. Well, that did well, didn't it, Katie Joy? So then she take that. Derek Dillard sends a message to Josh, apparently. I don't know. I think you can assume all that you like, but there's no proof that's for Josh, in my opinion. Okay, and then we've got. Look, she actually credited a source. He likes a tweet. I pray he gets the max. So what? He likes a tweet. I like lots of tweets. Cameras aren't allowed in the hearing. There'll be no audio or video, so there'll be no updates as the hearing is already sentencing takes several hours. And then and she's describing the Sun's live feed via the Sun. This will knock down his score a bit, but he could be near at the top of the guidelines. I expect no less than a 15-year sentence from the judge. So she went from 12 to 15. He'll be out in 10, unfortunately. Then she says he has a level 2 enhancement removed from. This would put his final score at 36 or 38, which still places him inside 20 years. 12.5 years. So she was wrong on both counts. And so she's just been on the Duggar bandwagon. Apparently he's going to serve his sentence in Texas, apparently. I don't know why. Allegedly. Then she said this, which was then, she had to do a correction because she made a mistake. Then this is the sentencing report, apparently. See, he's advised the right of appeal. He's going to appeal it. I have no doubt that. I mean, and that's his right. Whether you agree with it or not, he has a right to appeal his sentence. Everybody does. Look, now she's got excited over this. Saw this headline. Yes, Terry, she said, first of all, she said 40 years, then it went to 20 years, then it went to 15 years. So now the Daily Mail is involved. So and the other thing is she's sharing it. If I was being sued by Todd Chrisley, I wouldn't be sharing anything like that at all. Anything like that. But that's just me. So anyway. Based on that, I'm thinking, I'm going to head off now. I've still got to do heaps of study to do. Plus I'm working tomorrow, and I need to do the final preparations for work tomorrow. But thank you for joining me. I'm sorry that whole filing was so confusing. Usually they're very straightforward. Usually it's very straightforward, but that was complicated. And I think some of her allegations in her counterclaim were a bit fanciful, in my opinion. Fanciful. And because, as I said, I listened to those podcasts and I did not once hear anything negative said about her child. And I have no doubt that Chrisley would have probably have checked with his lawyers prior to starting that, prior to say anything. Based on the fact he knew what she was like. So I'd be very surprised if he didn't check with his lawyers before making any of those statements. But anyway, I could be wrong. I've been wrong before. But as I said, thank you for joining me. Make sure you hit like and subscribe. Ring the bell so you can see next time I'm live. I don't know when that will be at the moment. I've got exams coming up. Once my exams are done, I will be in touch. I'll be back live again. I've got 4 weeks break. And she assumes they were talking about her. Yeah, that's what she's assuming. Anyway, so thank you all for watching. Catch you next time. And for now, I'll bid you farewell.